You probably won't be surprised to hear that rules play a pretty big role in law. Legal philosophers agree that understanding law requires thinking about rules, but they disagree about the nature of rules and the precise role that they play. What is a rule exactly? Does law consist entirely of rules, or is there more to it? On a simple theory of law, law consists entirely of rules. Specifically, law consists of all and only the rules made by the lawmakers identified in the rule of recognition. Courts hear disputes, identify the applicable rules from within the set of legally valid ones, and apply those rules to the facts. Consider a town ordinance stating animals shall not be brought into the public library. Somebody who brings a Great Dane into the library has definitely violated the ordinance. A child who brings his stuffed bear into the library has definitely not violated the ordinance. These are both cases in which the rules apply unequivocally, dictating definite results. But what if someone brings a goldfish in a plastic bag of water? In that case, it's unclear how the rules apply. Is a goldfish an animal or not for the purpose of the ordinance? HLA Hart contends that cases such as these are inevitable in any realistic legal system. Natural languages have open texture. Every word has fuzzy edges, a core of settled meaning, and a penumbra of unsettled meaning. Great Danes fall in the core of the term animals in the context of this ordinance. Goldfish fall in the penumbra. Teddy bears fall outside the penumbra altogether. They're definitely not what the ordinance means by animals. Hart claims that there are no legally correct answers to questions involving the penumbra. We can say neither that the law allows goldfish in the library, nor that it forbids them. Accordingly, before the court decides the case, we can say neither that you're legally permitted to bring your goldfish into the library, nor that you're legally forbidden to do so. In such cases, Hart concludes, courts must exercise discretion, deciding on the basis of considerations that go beyond the scope of the law. You were assigned a famous paper of 20th century legal philosophy called The Model of Rules by the American philosopher Ronald Dworkin. Dworkin challenges the model just described. His key observation is that lawyers don't limit themselves to rules in crafting legal arguments. Rules are important, but lawyers use other kinds of standards too. Sometimes they appeal to what Dworkin calls policies, standards that set goals for the improvement of the economic, political, or social life of the community. Keeping the public roads safe is a common policy, the policy of public safety for short. Lawyers also appeal to what Dworkin calls principles, standards required by justice, fairness, or some other dimension of morality. Innocent until proven guilty is one familiar legal principle. In interesting cases, lawyers commonly appeal to principles in their arguments. Dworkin illustrates this by recounting the facts of two court cases, Riggs v. Palmer and Henningsen v. Bloomfield Motors. Dworkin references these cases because he believes that the courts in these cases gave legal weight to principles at the expense of rules. Although this isn't always appropriate, sometimes it is. Dworkin has three basic points. First, rules and principles are different kinds of standards. Secondly, lawyers appeal to both kinds of standards. Third, both are part of the law. Dworkin's work encouraged legal philosophers to recognize that legal reasoning often appeals to standards other than rules. They've debated what makes a rule and what makes rules different from other standards. However, Dworkin's original discussion of these matters is confusing. He describes rules as applying in an all-or-nothing fashion. If a case falls under a rule, then the rule applies. Any exceptions to the rule could, in theory, be stated explicitly. Principles, by contrast, do not apply in an all-or-nothing fashion. Consider, for example, the principle used by the Riggs Court, no man shall profit from his own wrongdoing. This principle looks absolute. It seems to require courts to prevent any party from profiting from his own wrongdoing. But courts aren't actually so strict. As Dworkin notes, there are many cases in which courts allow people to profit from wrongdoing. Illegal squatters can eventually acquire title to land under the doctrine of adverse possession. Employees who breach job contracts in order to take higher-paying jobs are permitted to retain their higher salaries, etc. The no man shall profit principle does not always control the outcome, even when it applies. Rather, it operates as a pro tanto reason to prevent wrongdoers from profiting. You'll recall that a pro tanto reason is a reason that has some weight, but that can be overridden by stronger reasons. When a principle applies to a case, other principles usually apply too. In any given case, the correct outcome depends on the balance of applicable principles. Writers since Dworkin's paper have generally agreed that rules differ from principles, although they've not always agreed with Dworkin's way of drawing the distinction. Dworkin also made the bold claim that his observations about the role of principles in legal reasoning undermine some central theses of the positivists. Consider the positivist idea that laws are primary rules enacted in accordance with procedures specified in a rule of recognition. Cases such as Riggs and Henningsen were decided on the basis of principles that were not passed by legislatures. Such principles are not formally enacted or formally repealed in accordance with procedures specified by a rule of recognition. Rather, such principles emerge gradually as courts begin to cite them in their reasoning. When principles erode, they do so gradually as well. Courts make decreasing use of them over time. No formal test, such as a rule of recognition, exists for whether a given standard is a valid legal principle, or how much weight to give it at any given time. To determine how much weight to give a principle in the case at hand, we examine precedent and see where the principle has or has not prevailed in the past. Dworkin also challenges H.L.A. Hart's claim that judges exercise discretion in hard cases. Where the rules don't determine a unique result, Dworkin says, judges must turn to the broader set of legal principles in their system to reach an answer. Most controversially, Dworkin defends what's known as the right answer thesis, which states that there is a unique, legally correct answer in virtually every case that arises in a well-developed legal system such as ours. Dworkin's theory of law continued to mature over the years, culminating in his monumental book Law's Empire. There, Dworkin defends a theory of law that he calls law as integrity. You are assigned an excerpt from this book as well.